1919 is a dark year in American history. Turmoil, terror, and intolerance haunt the land. Economic hard times have unleashed a wave of disruptive strikes in industry and even in public services. Race riots flare in several cities. The Ku Klux Klan is revived. The specter of the Russian Revolution, proclaiming an international uprising of workers, strikes fear into the hearts of many Americans. A radical minority, among them socialists, communists, and anarchists, seize the moment to wage an all-out war on capitalism. Their tactics include terror bombings targeted at key public officials. The government's response to this so-called Red Scare is also extreme. Both federal and state governments begin a harsh crackdown on political dissent. In November, U.S. Attorney General A. Mitchell Palmer initiates the Palmer Raids. Thousands of suspected subversives are arrested, and hundreds of undesirable aliens are deported. But some question whether the government's response is constitutional. The founders valued freedom of speech and freedom of the press as natural rights and essential tools of self-government. The young republic, they realized, would not survive unless every individual had the freedom to criticize their government. These rights were expressly guaranteed when the First Amendment was added to the Constitution in 1791. But by 1798, President John Adams' administration had passed the Alien and Sedition Acts, which restricted the activities of political radicals who were hostile to the administration. These acts raised, but did not answer, the question of just how far freedom of expression should extend. More than a century later, the U.S. Supreme Court would finally have that chance. In the midst of the domestic turmoil of 1919, the Supreme Court heard several landmark cases concerning the constitutional protections of free speech. These cases arose from two acts of Congress, the Espionage Act of 1917 and the Sedition Act of 1918, intended to prevent subversive activities during World War I. In Schenck versus United States, an official of the Socialist Party was convicted under the Espionage Act for distributing leaflets urging resistance to the military draft. Justice Oliver Wendell Holmes spoke for the entire court in upholding his conviction. The government, Justice Holmes declared, had a right to restrict freedom of speech when there was a clear and present danger of causing substantive evils. By November 1919, however, Justice Holmes began to change his view. In Abrams versus United States, a majority of the court upheld the convictions of Jacob Abrams and others for distributing propaganda urging workers to undermine American military actions against Russia. Joined by Justice Louis Brandeis, Holmes dissented, dismissing the propaganda as harmless and praising the ultimate good of the free trade in ideas. 6 years later, the two justices would again dissent in the landmark case of Gitlow versus New York. This case involved the publications of a radical socialist convicted under New York State's Criminal Anarchy Act. Holmes noted that every idea is an incitement, its fate to be determined by open and free discussion. Though the champions of freedom of speech would lose all of these early landmark cases, Schenck, Abrams, and Gitlow marked the beginning, not the end, of securing freedom of speech under the Constitution. Within a few years, freedom of speech would be recognized by the nation's courts as a fundamental right, one of the preferred freedoms given special protection by the Constitution. But even fundamental rights have limits. As these landmark free speech cases make clear, finding the right balance in the nation's commitment to both order and liberty has never been easy.